Hi, good morning, everyone, and happy Friday. It is finally Friday. I get to say that. I haven't done a live on Friday. So happy Friday. And I have someone very special on today's live call. I'm going to let her introduce herself. But for those that don't know her, she is an amazing HR specialist. She's my go to person for HR, and she has several years of experience. So I'm here to present you Miss Velma.
Oh, thank you, Rocio, and happy Friday to everyone. We made it through the week. Hi, everyone. My name is Vilma Breaker. I'm with Inside HR Consulting, and I wish I only had a few years of HR. I'm going to age myself 24 plus years in the field. So, and a lot of that time has been here in California, which is a never ending changing situation with employment laws. So, I'm happy to be here, and I'm thrilled that it's Friday.
Well, we are very happy to have you because, as everybody knows, California is an ever changing state. It is an employee friendly state. It's the same way as New York works. There's a lot of compliance laws, there's a lot of labor law issues, and every year it changes. And I always say insurance is completely separate from HR. And I have to remind this to my clients because they do overlap in the senses that HR manages certain things and aspects of the business, but it's completely separate because there's a lot of compliance, there's a lot of things that person who's running HR has to know. And if you don't know what you're doing, you could be in really big trouble because California has very distinct and very strict laws that pertain to that. So I thought I would open up to a very common question that I get, which is documentation, but to be specific, how to handle documentation and what to do when you are terminating someone. So that's a huge issue. We've seen it a lot. There's a lot of labor law issues with wrongful termination, people not showing up to work, people calling out early, and especially in the staffing and construction industry, there's a lot of turnover. People get hired really quick. People get fired sometimes really quick too. But you have to be very careful on how you terminate someone. So, Ms. Velma, what advice do you give to employers on how to, I guess, how to properly terminate someone?
Absolutely. Well, let's really talk about California, but actually, this can be applicable in any state. So, you mentioned New York. Keep in mind New Jersey, Washington. They're moving towards very much like California employee friendly employment laws. Okay. So, for terminations, we can literally speak 8 hours and may not be sufficient. But at a minimum, when HR or any individual is asking you to document, because we are supposed to be an at will state, but with all the lawsuits that are coming into play, the documentation is the one process that if you do really well on can mitigate the cost of a claim or
Yeah.
litigation
And sorry
or
to
even
cut you off on that, but I think that's a very important topic to touch at will state because I've sat in several meetings with employers saying I thought I could do that because it means at will, so meaning like if I don't want him and or her, they could be terminated. So why does California say at will but it's not really an at will if you decide to say I'm done with this person, cut them
yeah.
off?
It's because we have so much employee friendly policies, right? Like discrimination, retaliation, anything with protective categories. Anyone and anything could back up a discrimination lawsuit, right? Or a retaliation because we have so much protection under California employment law that if you don't really have great documentation, you're just opening up a larger litigated amount, right? Documentation and understanding, even though it is an at will, I always encourage our clients, you got to have a good reason and you have to have data and information to back up the documentation. The states where you can say, we just don't like the way Vilma looks today. We don't need that position anymore just because it is Vilma. That doesn't go well here, okay? Because Vilma can always come back back and say, I was wrongfully terminated because I'm Hispanic, I'm going to age myself again, I'm over 40, or I have a medical condition, or many other reasons. And I can easily attain an attorney here in California, and they will throw just about everything you can think under the sun to see what can apply for that separation. And of course, an attorney who's representing a client, they're going to come back and say, okay, why did you terminate Vilma? Well, we just didn't want her. Okay, why not? There's a lot, even that discussion is going to be costly, right? So the documentation piece of it, when you are actually thinking of terminating somebody, there's going to be a reason behind it. If the reason is 100% because we just don't like Vilma the way she looks, remember, there's a lot of protected categories here in the state of California that could result in litigation, right? So the best route to take is have a good reason why you're terminating somebody, and that also means documentation. Have good documentation. You have to show good faith effort as an employer that you try to work with that individual and they're just not making it, right? It's just not working out.
And how does that documentation properly look? Because I've been in situations as well where there is documentation. Maybe it wasn't, written correctly, or it wasn't in their employee handbook as to how things were to be written up. So how does someone protect themselves? Because I've had, maybe the insured took little notes, like I wrote them up, or here's a little form where they just said they were written up with the reason and the date, but nothing much, just the basics, just the date, reason, signature, and they have that. But then the attorney comes back and says, well, this was on this employee handbook is out of date. You have an employee handbook from 2008 and we're 2025.
It happens. I'm smiling because it happens often, right? So first of all, just keep in mind, as an employee, we would definitely encourage to have a handbook. But in the state of California, you're not required to have an actual employee handbook. You are required to communicate process and procedures or policies to employees. So literally, you can have a standalone attendance policy, right? Because that's extremely important for your business. Then you need to communicate that to an employee so they understand the expectations of it. And then obviously you can hold them accountable. And hopefully, once you understand what the attendance policy is, then you are holding people accountable. And every stage, you should have a conversation with that employee. You coach them the first time. Maybe it's just a verbal. Stop being late. You were late 5 days this week. I need you to improve next week. Well, here I come next week and become late again. I do need to follow up now with some form of documentation. Okay? And I would always suggest you start with a verbal written that communicates, I talked to you last week asking you to be here on time. You were 5 minutes, 5 days late consecutively. Moving forward, we need you to be on time every single day. And provide them that notification. If they sign the notice, that's great.
And is there a standard in California of how many days someone could be late?
No.
I get that question a lot. This person's like, usually it's the third strike where like I'm out. But I asked them, like, well, did you write this up? No. Well, we don't have much.
That's where the problem is, right? It's like, well, how can I prove that the employee was aware of my attendance policy per se? And if it's not documented or signed off, it's just he said, she said, and here we go again. Now we have to have a much further discussion and how we're going to prove it, right? So again, like I said, you can have standalone policies. If you have a lot of policies at that point in time, then it makes sense to have a handbook, right? So in that handbook, if you have not used it and it's been on the back room since 2008, you might as well throw that away and start a new handbook. We tell our clients it's a livable document. It's like whatever is in there, you're practicing it. Please, this is another error we see when we come in discussing handbooks. A lot of payroll companies will provide you a template. Or you can get it online, okay? You have to be very careful because we have seen so many different kinds of templates that there's a lot of policies in that handbook and the employees have that handbook. Whatever is in that handbook, you are living it. So if you're a small employer of 30, 40 employees and you offer FMLA, CFRA, then you're going to offer FMLA and CFRA, even though FMLA is not eligible to you because you're not hitting the 50 head count, right?
Yeah, we have a question right here. Oh, no, go ahead. You finish, finish your thought.
Yeah. And then of course we have other things in there that if it's not a California handbook, overtime, you might be assigning overtime incorrectly. And that's a lot of lawsuits here in California. We have a ton of wage and hour lawsuits, right? And so we want to make sure whoever you're working with, that you really have somebody specialized in California employment law. Because if you're putting it down on the handbook, you're going to be held accountable on that handbook. So you want to make sure that what's in there, the content in there, makes sense for your business, that you're practicing it. And again, you can change policies throughout the year. You can add, take away. It's just the communication piece of that. And then making sure you're consistent in holding everybody accountable.
Yeah, no,
Okay.
100%. So we have a question from William. Hello, are the employers required to have any type of signed documentation that is signed by the employee to prove that they received compliance policies? Great question.
Yes, I would highly encourage you to have, if it's a standalone, attendance policy per se, not only should you give them the copy, but you should have an acknowledgement form that the employee signs off on it. They have received, they have reviewed the attendance policy, my name and the date that I did that, right? Same thing with a handbook, right? We always encourage, you don't have to spend an 8-hour day going page by page on the handbook, but you need to understand what's essential for somebody to know and understand day one. At a minimum, you got to cover that. Tendency is always attendance, safety, right? Benefits, if they're eligible for benefits, anything to do with some of the leave of absences, some of the uniforms or require attire. At a minimum, you got to understand what do they need to know day one, because we're going to hold them accountable for that on day one, right? And then you provide a copy of the handbook. And then you also want to make sure you have an acknowledgement signed by the employee that they received the handbook. Okay. Now, like I said, you're not going to review every little detail in there, but in those particular situations when there's some specific policies, I would encourage you to list those specific policies and have that employee sign off that you reviewed that with them on day one or the first week. So that can substantiate the fact they were aware this is what was expected for them.
Wow, you just put some fear under my butt. Well, because a lot of employers, they just do. I mean, I'm thinking about the way I got hired into the insurance world. I only signed one piece of paper, which is like, I acknowledge that I received my employee handbook. Here you go. And I think a majority of employers do that. The one thing I do know that people focus on is the benefits part. And then anytime someone does safety, OSHA related, they can collect signatures
Yep.
and the employee handbook itself. But that's very important that you bring that up, because I know for a fact that I didn't do that when I started in the insurance, or even like any of my prior jobs, on signing off certain policies. And that's very important, because as an employee, you don't really read those handbooks. I think there's some people who do take their time to actually look through it and know what's in there. But a lot of us just kind of get it, sign it, throw it away.
Yeah. And that's usually 9 out of 10. That's the process that is active, right? And that's the minimum. You should have an acknowledgement from the employee receiving the handbook. But if you actually have an orientation, right? I've been in companies that the orientation actually takes 3-4 days because they go really in depth in a lot of information. And every time they do something like that, they do have a follow-up acknowledgement, even though they received the handbook and they acknowledge overall all the policies within the handbook, that they got a copy of it. They touch on certain ones, right, that are very critical for their operation or for the employee's understanding on day one. And what we have seen in practice, if you have a situation like that, if you do have an orientation, you're covering certain aspects of the handbook, one pager. We review these policies and have the employee sign on the bottom.
Yeah. Another one that's common is a cell phone usage policy. I've gotten, clients, employers call me up and say, hey, this guy, he's literally on his phone. He shouldn't be on the phone because it's a field, it's a safety hazard. They're on their phone, or the ladies in the office, or it's work time and I see them on social media. But what do I do about the cell phone usage? And usually I go back, well, what's your cell phone policy?
Yeah.
Don't have one, or don't use it at work. But there's no knowledge as to like what would happen. Like if you're caught using your phone, what are the consequences of it?
Yeah. And usually what I would recommend, do progressive discipline, right? A progressive discipline approach is you'll start with a verbal, then you can, if they do it again, you do a written. If they do it again, perhaps you follow up with the final until you determine whether that individual case, they're not getting it. They're just not following instructions at all. They're very unsafe. And then at that point in time, you're going to have to make a decision whether that person needs to continue employment with you or not, right? But at a minimum, you're showing good faith from an employer perspective. You're trying to work with that employee, and it had nothing to do with the protected categories. You see what I mean?
Mm-hmm.
The decision for separating in Vilma is because she was not adhering to our policies, our safety, our cell phone, whatever that may be. And she has been coached through, and then unfortunately we had to make that decision. It had nothing to do with her being over 40, being a female, having a medical condition, and many other things, right? Those are all protected categories. I can substantiate this is the reason behind why we separated Vilma.
Yeah. And I'm going to bring in something that's also dealt with too. When someone is when someone is about to get laid off, terminated, or they know they're going to get terminated, but all of a sudden they get hit with a workers' comp claim. This is a big fear, and with many employers, and this is a topic that actually I touched on with my defense attorney on Wednesday, and the employee was supposed to be, terminated a week, after, or the following week, but now they can't, or they're fearful that if they terminate them, the workers' comp litigation will come in.
Mm-hmm.
So how does an employer protect himself? Because sometimes, things are it's just a safety concern, or this person is not following the rules, but now the employer feels stuck and pressured to keep this
Mm-hmm.
person on payroll until the
Yeah.
workers' claim is over. So how
Yeah.
does one protect themselves against that type of case?
Yeah. That's very difficult to also, it's a difficult process because whether you have legitimate reason to terminate somebody under a workers' comp claim, they can easily come in with a 132A, right?
Mhm.
That, it is a claim that you terminated them because they were on a workers' comp. That's where the documentation comes into play. And anytime we have certain situations like that, there might be a protection based on a leave, based on a category, we definitely want to take legal counsel involvement in that discussion. So that documentation makes it a lot easier for myself as an HR professional or an attorney or a combination of both of us to determine, that risk from that might be very low because we can substantiate that the reason why they're being separated has nothing to do with the claim, right? And so we just need to study what's the reason behind it. And you can still separate somebody on a workers' comp claim. Can they become litigated at any point during that open claim? It can become litigation, right? Under workers' comp. How can we avoid it? I can never guarantee that. But at least you're not going to get a 132A, and if you do, you have opportunity to argue the fact that that's not the reason why that person was separated, right? So that's where the documentation comes into play, and it's so critical because that is the only proof an employer has that had nothing to do with protections, disability, entitlements. You actually did a decision based on the policies and procedures that you have, not because it is the individual, but it is because of that they're not following what the expectations are for everybody. Now, that being said, the only other thing I'm always preaching about is consistency in the application of those policies. So if we're going to hold somebody accountable for the cell phone, for that attendance, we're going to hold everyone accountable for it, right? Not just pick and choose, because then that also creates a problem, right? So if an attendance policy, I'm supposed to give out somebody a verbal after 5 days of being absent in a 12-month period, I'm going to have to give it to everyone that has the exact same amount of absences in that 12-month period. Does that make sense? That's consistency of applying that application. I shouldn't be picking and choosing who gets it, right? I need to be as consistent as possible once we have a policy in place to communicate it and the application of it.
Yeah, very important. So when someone terminates someone, I know there's different laws and different rules as to if you terminate someone that same day, you need to cut them the check, right, or give them the check if they're terminated, or you need to pay them within a 3 day gap,
Yeah.
right, or 3 days. three
Yeah,
days.
and that's different in every state, right? It's a little bit different in every state. In California, I'm going to tell you what you're required to do. If the employer is making the decision to terminate someone, the date I'm communicating to the employee that you're being terminated as of today, on that day, I need to have final pay that includes all hours work, including that day of termination, right? If I have any unused but accrued vacation, that also needs to be paid out on that day. Okay? So that's very important. Second situation, if I give you more than 72 hours notice that I'm leaving, so today is Friday, I'm going to tell you, my employer, hey, next Wednesday is my last day, right? Well, on Wednesday, because I provided you more than 72 hours, you need to pay everything out on that Wednesday. Okay? Now, if I come to you and say, Rocio, today's my last day, I'm done. This is it for me. It's Friday, I'm out. I have 72 hours to pay me out because I just notified you that today was my last day. Okay. But remember, at the payout, if you are offering vacation, which by the way, you're not required to offer vacation in the state of California, but once you do, there's some rules that you have to follow. And that means if I have not used in my time off, my vacation, PTO or vacation, and I have 24 hours in balance, you need to pay that out on my last day of employment. Okay. Also, if you offer sick time as a standalone policy, you're not required to pay that out.
And there's a 5 days in sick time for in California, right?
It is now 5 days since last year, 40 hours. And then please keep in mind if you're in the city of Los Angeles, Santa Monica, San Diego proper, they have their own ordinance for sick leave. So it's not the standard 40, it's a little bit more. And please, God forgive if you could work in San Francisco, that's a lot more hours under sick. So, but
Oh,
yeah,
wow.
you got to pay attention on those ordinances depending on the city that your employees are working in, not where they live, but where the work is being done.
And is there a certain time that the employee needs to report that he or she is sick to the employer? So
Well, when
let's let's say like me, I'm working for you, and I'm supposed to come in, but then all of a sudden, like 1 hour before, I say, "Hey, Vilma, I'm not feeling too well. I'm gonna call off. I'm gonna take a sick day."
that's fine. And my question would be, okay, you're going to use your sick hours.
Mm-hmm.
Because in here in California, they can use at a minimum a 2 hour increment sick hours, right? So if you're coming into work right now and it's 11:23 and you were scheduled to be with me today until 5, but you come in my office, you tell me, I'm feeling really sick. I'm going to go home. I'm just going to go home and be, I'm really sick. I don't feel well. Okay. Thank you for letting me know, Rocio. Are you taking sick hours for the rest of the day? Or are you just taking off for the day? Because the employee has to say it. I want to get my sick hours. I cannot just assume. So if
Okay.
the employee did not specifically say I need to take my time off under paid sick leave, then me as the employer, the representative, the manager, the leader, I need to be very clear. Are you going to use your sick hours? Because if you are, then I cannot hold you accountable for any attendance issue, right? For leaving early, because that's a protected leave, right? If you have those hours and you're using it. And you'll say, yeah, I definitely need, please use my hours. Fabulous. Not to worry. I hope you feel better. And I really do hope that you feel better. Let me know if you can't make it on Monday. If you cannot make it, make sure you call me Monday before you start time. Okay, Rocio? You got to be that clear because, here comes Monday and you don't show up and you may have an attendance policy that if you don't call in within the first 4 hours, that's a no call, no show. And that could be separation, right? Or termination or something like that based on the attendance policy. So we need to have some clear communication, right? And I always would follow up with some form of documentation, whether that is via emails, just reaffirming you're going to take the time off as sick, and things like that. Just we want to showcase that we as the employer are doing the best that we can and the right things and applying our policies consistently.
So if someone takes their sick time, how many hours is the employer supposed to pay the employee?
Well, it depends. At a minimum 2 hours, right? So if you were scheduled to be here until 5, and that was an 8-hour day for you, and you've only worked 3.5, that's 4.5 hours, right? to make it a whole day. So it's a
Mhm.
4.5 hour, 6 hours that are going to come out of your bank.
Okay.
Yeah.
Yeah, I think there's a lot of tension. I always have employers say, like, this person said sick, but then they literally text me 2 hours before, but they know that the policy says that you must give me a 4 hour notice, especially with restaurants.
Hmm.
Unfortunately, this is a big issue. Same thing with staffing. People will call in sick, call in late, and there's a lot of issues between that and the reporting of it. And I think that's what might create the tension as well, because then the employer or the supervisor may have not, or the employee may have not clearly communicated that with the supervisor. So now the supervisor is like, well, I didn't pay you because you just said you're taking off the sick, but you didn't tell me to use your sick hours.
Yeah. And here's the pain of that too, right? Most construction companies, most staffing companies pay week by week, right? Every
Mhm.
weekly pay. So as a leader, as a supervisor, generally, if you get a payday on a Friday, 100% of your payroll should be done by Wednesday of that week that you're paying on Friday, right? So I have the responsibility as a leader, as a supervisor, a manager, knowing that, Rocio, you were off today, right? You were sick, you were gone. I need to do a follow up on Monday somehow to figure out, are you taking sick hours, or you left early, right? We need to have that payroll discussion to make sure we pay the employees correctly. Now, I do see this happen quite a bit where the employer is trying to figure that out, and here's the deadline. So, what do I do? What I recommend is like go ahead and pay all the hours that you work. As soon as you find out, you might have to cut another check for that because you have to get the affirmation from the employee, right? You can't just make the assumption because there's been cases where I didn't want my sick hours to be paid out and I paid you, right? It really is up to the employee to request it. We can't make the assumption that, yeah, you're going to get paid sick hours because they may not want to use it. Maybe they have other things going on. They'd rather take that point in the attendance than utilizing the sick hours, right? So we need to have that clear clarification documentation to make sure that we pay as soon as we are aware how they want to be paid, right? It's the process of trying to do the right thing, but you got to substantiate it with documentation that as soon as you know that that's exactly what I want to do for my sick hours, then you're paying it accordingly.
Yeah. So let's talk about time cards. Time cards are the reason why a lot of people get dragged into. If you ever been into a wage and hour issue, class action, any type of wage and hour, um, that is one of the biggest issues because sometimes people don't record or don't have any type of traction with time cards. They don't record their breaks. I'm saying that breaks out loud because breaks is a very common one. And if you ever get caught not paying people's breaks, that is a lot of money, a lot of issues. So, how do you recommend people besides the electronic form? Because the deal with construction is that sometimes there's an issue with employees not being able to log in to their phone via electronically, or they say, "Look, I was at the job site, but I totally forgot. But now I'm like 10 minutes in, but I was actually here 15 minutes before because I wanted to get here early, but now I can't track it on time." So now I've always had issues where people call me saying, "Hey, like this new employee or this person always has issues with their phone, so I'm just going to use a paper, and I'm just going to have them say they clock in at 7 a.m. and leave at 4 p.m., which actually that is not the right way to do because you need to actually record the time that the person gets on the job."
Okay. So I have a two-prong recommendation. This one. First one, employers. You got to train, educate, and hold your leadership accountable. They are representing you out in the field. What they do or don't do is a representation of the organization. So we as a firm, we spend quite a lot of time educating and training and developing leadership because you have to give them the tools to be able to manage through all those situations. Because again, they're representing the organization with decision making every day, right? So first they need to understand what is the law, what is the requirement, what do I do in situations. Let's give them the tool and knowledge first. Now you have employees, okay? And with field employees, yes, your phone, your time and attendance, however you're capturing your time and attendance, you got to make sure the time and attendance rules are set up accurately, because that is a very helpful platform to have, because that will alleviate a lot of stress and a lot of confusion, not just for payroll, but from leadership perspective too. So if you have a mechanism, and again, we are more than happy to refer quite a few of those platforms that are working really well, because we are managed through a lot of the stuff. But if you set up your time and attendance rules accurately and tier it up for individuals of leadership to be in the know for certain things, you're going to capture a lot of information pretty quickly and be able to fix it pretty quickly, right? So there is a lot of huge technology out there that is extremely helpful, but it's only helpful how you set up the rules. So the rules itself within that system is extremely critical. Now you set it up all accurately, right? And the employees, because let's face it, I think I shared with you, technology is not my friend either. Okay, technology and I don't have a great friendship, but we have to figure out our workforce, right? If technology is not the best friend to them, what other mechanisms can we utilize? That could be a form, a timesheet, okay? But again, leadership needs to review those timesheets on a timely manner. And to your point, we do have several construction companies that we help. They every so often get audited,
Mm-hmm.
because the construction company has gotten in a lot of trouble when they get audits and they see all their employees clocking in at 7, taking their first break or their lunch break at 11, 11 to 11:30, and they clock out at 7:30. That is not realistic. That does not happen in the real world. And our government agency know that. So if you are having that kind of situation, you got to tell your employees to clock in and out actual time. If they were scheduled to come to work at 7 and they're running it, but they're actually getting out of the car at 6:50, getting their tools and actually working, they're working from 6:50, right? That doesn't mean they have to stay all the way to 3:30 to get their 8 hours. If they're done early, actual time off, right? Now the lunches, yeah, that's a little bit more reasonable, because then if you may require everybody to have a lunch at 11, and that's a little more reasonable, right? But let's just make sure that it's not every day 11, because sometimes you're late. Sometimes you're walking at 11:05 and starting at 11:05. So actual hours are essential. So if you have a large workforce in the field, having standard 7 to 4 with specific timeframes, that's a red flag for a lot of government agencies. Then what they'll do is they'll go more in depth. They're
Mm-hmm.
going to find more different dates and times and going to talk to employees. And that's where, a lot of more problems arise.
Yeah, I've seen that. I've seen attorneys redline the 7 a.m. to 4 p.m. Like everybody does this, all, 200 employees, time cards.
Yeah.
And then they'll look at the dates and they say, why does this dates look like someone, supervisor, has the same writing and puts the dates on there for every single thing? But we have different signatures, but that same writing, they'll pick you apart. And I'm saying this from experience, because I've seen that. And it also comes in with recording gas mileage. Since we're talking on construction, um, keeping record of that, keeping record of when employees are driving to different locations. You have to pay them for that,
Mhm. Mhm.
especially. And I'll let Velma talk about that because that's a very particular problem in construction. I've seen contractors get in trouble for this.
Yeah, drive time. If you're sending me, if my home base is in Ontario, and you hire me for a location construction out of Ontario, but then all of a sudden, oh, I need you to go to Alhambra. Well, that's first of all, it's working hours between Ontario and Alhambra, and then my mileage too, right? So that's called travel time, and you have to pay employees for travel time, and so those become extremely complex because
Hmm.
there's so many different scenarios. Anytime we have a construction company and they have those similar situation, we definitely want to bring an attorney in that specializes in employment law, wage and hour, because we want to make sure that everything that they should be getting paid for, they are getting paid. And there's documentation and a tracking mechanism. And again, to avoid any future litigation, right? And
Hmm.
again, not everybody's perfect. We just need to assess, right? We need to audit what our current practices are. And there's always a solution if we're not doing it right. Just keep that in mind. It's like Oh my God, I've been doing that for the last 20 years. Okay, well, at some point we need to change it. Let's change it now. Let's figure out what that means. What does that look like? We'll probably have to bring an attorney in, right? Because if we're going to make changes and we're fixing it, we definitely want to fix it correctly and timely. And there's always a solution, all right? So please don't be scared that if things are not being done correctly within your organization, there's always opportunities to change to make sure that we do. And how does that correction, what does that look like for us, right? We will always involve an attorney to make sure you get the right guidance and solution based on that particular situation. But yes, in essence, if we're asking employees to drive from one location to the other, we have to compensate them for at least mileage, right? If not hours that they worked. Because if they're during the working day, they should be getting compensation. We are sending them from one location to the other. That's hours working for us. And then if we're asking them to utilize their vehicle, at a minimum, we need to definitely compensate them with mileage. And sometimes what I've seen happen is that we ask employee, "Oh, take the ladder, from one place to another." Absolutely, that should get paid. And we're asking them to utilize their vehicle for the company's benefit, to even if it's a ladder or paint or you know
Picking up material, that's a big
yeah,
common one.
materials or whatever it is. If they're utilizing their own personal vehicle, they need to have some form of compensation. And I say some form of compensation because it could be a car allowance, it could be mileage reimbursement, right? Or stipend. So there's different ways, but we need to kind of clarify that. And every company is a little bit different. So I'm generalizing quite a bit, but there's a lot of different ways to resolve that situation.
Yeah, and that's very common for employers because construction companies usually have their own fleet, and that's designed for the people for the new hires. They usually most often use their own car to go to job sites, different job sites, and that I think that's one common issue that I get a lot. You're sending someone from Riverside all the way to Long Beach,
Yeah.
and now, the employee saying, well, hey, I used to only work in the IE. Construction projects change. It's all
Yeah.
about landing work. And now the employee saying, well, now I have to wake up at 4 a.m. to beat traffic to get to Long Beach by 6 a.m. Or, I have to be up by 4:30 a.m.
Mm-hmm.
versus when I used to be at 5 a.m. and make it to work by 6 a.m.
Yeah. Yeah, those are the things you have to like pay attention to and consider. Okay, how if I was paying Vilma to travel to Ontario and now I'm sending her to Bakersfield, when do I need to start paying her? Right? When is her day starts for hours to be paid out? We have to figure that out. And there's so many different kinds of scenarios. I don't think we're going to be very clear on this podcast because there is a lot of different situations, right? A lot of different, especially in construction. But construction is not the only field or industry that has those similarities. You have healthcare industry that also has some very similar situations as construction, believe it or not.
Travel nurses.
Yeah, especially exactly, right? And the same thing with the pay, per diem, and all these other things. So we just got to make sure, like, whatever industry you're in, that you have the right wage and hour wage orders for your industry, and you have a really good understanding what that looks like, an application for it. And then you have a process, systems in place that'll help you through all of that. And then please, 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 please train, educate your leaders because they are the people that are managing all of this for the company, especially if you have field employees, right? So that education is essential. We're always like, you got to train them. You have to give them those tools because they are the ones, your first step of defense, right? Like we're doing things right, and they have to understand what is doing things right look like. And if something is off or not being done correctly, they're the first one that need to call it out. So your corporate, your HR, your payroll are in the know so we can come up with a solution.
Yeah. Another question from William. Are there any employee compensation requirements when the employer requires them to use their personal cell phones for the day to the day operations?
Yes. In California, it's not new. There's several years that it's been at play. that if an employer is expecting or asking an employee to use their personal cell phone for company process procedures or information, that we should give them a reasonable reimbursement. Now, what I do see, and this is something in the construction industry, that corporate handbook says absolutely no personal use for your cell phone. But then you have your foreman, you'll have your superintendents, not knowingly, and usually does is not with is not intended to be with malice, right? But they'll ask their employees, "Oh, you know what? Take a picture of that and send it to me if it's messed up or if you're missing this or the other."
Hmm.
Guess what? Now we're asking those field employees to utilize their personal cell phone for company usage, right? Even though the corporate office has the policy in place, no, we don't do that. Yes, you are doing that. And therefore, we need to consider a reimbursement. It doesn't have to be a lot, especially nowadays. I mean, you can get a nice, cell phone package for like 40, $50 a month. You don't have to pay the whole 40, $50. But reasonable can be $10 a month, maybe $25 a month. We have to kind of figure that out and understanding how much usage we're asking those field employees when it comes to their personal cell phones.
Yeah,
And
I mean,
trust me, it is happening.
mhm. Oh yeah, I was going to say that. Like insurance agents, we use our personal cell phone, and for the smaller agencies out there who run their own brokerage, yeah, if your agents are using their personal cell phones to call clients, send messages, send emails, they are using their own thing. So you have to look into that because there's also cases for people who work in the office on that.
Yeah. And again, that's a totally different industry, right? If
Hmm.
you are a licensed broker, an agent, because you have so many different kinds of lines for that, uh, you may be eligible to be an independent contractor. You may be an employee, and different rules applies to that, right? So again, if we are having employees W-2s, we have to be very careful, right? How they're utilizing their cell phone, their personal cell phone for company usage, right? If you're a true independent contractor, and I say a true independent contractor, just with AB5 and all, we can't just say in general anymore. We have to really look very deep whether that person qualifies or does not qualify to be an independent contractor. But if they do qualify for independent contractor, that's a different story. None of these wage and hour, none of these true employment laws apply to those independent contractors, right? And that's another podcast if you like, because that in itself can be a couple hours for discussion.
Yeah. And that's because those people carry their own insurance and they have their own entity. So sometimes people like, oh, when new construction companies are coming up, they say, oh, yes, it's my subcontractor. Well, does he or she carry their own insurance?
Mhm.
No. Well, when workers' comp, they are technically your employee because if anything were to happen, you are responsible. And you're also responsible for the wages. So
Mhm. Yes,
be very
absolutely.
careful with that. Yeah, guys. So, for those who are listening, if you guys have any questions for Miss Velma, go ahead and drop them in the box. If you guys would like to reach out to her personally, where would you like people to reach you, Velma?
Well, I'm going to be brave and have you call me directly. You can call me at 909 You can go under our website under www.insighthrconsulting.com. We have a little bit of social media. I just started Instagram, and I'm very heavily involved in LinkedIn. I am me or whatnot. I will always get back to individuals that reach out. So if I can be of any help, any support, any guidance, utilize me as a resource, feel free to do so.
Yeah, guys, she's amazing. She knows her stuff. And she already said her amount of experience. She comes from very reputable companies. They know her. She is honestly the best. I told my audience, you're a walking encyclopedia. Like everybody knows. Thank you so much, William. You have a great weekend too. And we're here to help. So we want to make sure that people are educated and know what to do because in the state of California, it's very easy to be out of compliance. That's why I always pound the desk on like compliance, compliance, compliance. If there's any updates with the law. I try to update and keep my audience informed. Of course, like I said, HR is completely different. So HR is
Mhm.
its own set of industry. And that's why Velma is the person to go to when it comes to anything HR related. So thank you so much for being on my live, Velma. And I know this is not going to be the only one because, like I said, there's so many topics. Today, we only touched termination, documentation. There is health benefits, there's onboarding, there is return to work. There's a bunch. And I didn't even talk about the FAIR Act, or how to deal when you have people who are in maternity leave, which is hot. I think that might be the next topic because that's one of the common issues. But yeah,
Anytime.
sounds good. Well, thank you so much, Velma, and thank you guys for being on here. And I hope you guys have an amazing weekend. Bye.